Scott, this question was sent to us by an investor friend out of the Houston market, and it's quite an interesting question that could go many ways. So I'm interested to see the legal way it should go. Okay, you ready?
Or legal or proper.
Or proper.
Okay.
What would you do if you had someone wanting to buy a home with owner financing that you are selling? You have pre-qualified and you have verified everything. It's Saturday afternoon at 3 o'clock and they give you $21,000 in cash. The moving truck is coming on Monday morning. Your contract is not signed and there's no disclosures. They have not been fully processed. Would you take the money? Would you take the money and on Monday get a cashier's check to document the down payment? Or would you decline them and tell them to go get a cashier's check and come back on Monday?
Could I take the money and run off to the Bahamas, maybe? No, that might be a fun thing to do.
That's not one of the options.
Okay, so, you know, it sounds like there was a buyer who has been interviewed over the phone by the investor and was probably pre-qualified through some basic questions. Of course, what we don't know is, has there been an application or tax returns or anything at all provided to the investor? But the way I look at this is, you know, we have a buyer who needs to move quickly. And that's fine. You know, there are ways to handle that that are appropriate. We don't have a contract signed yet. We don't have the disclosures. You know, about 98% of transactions that are out there that we work on have existing mortgages. And so we have to think about that underlying lien disclosure notice for that 7-day period where the buyer can back out. And we haven't processed the buyer. So the first thing, you know, I look at is, who is the investor? What is their position? In other words, how do they conform to the SAFE Act and Dodd-Frank? Have they done 5 or more transactions in the last 12 months? If not, then technically they're not under the Dodd-Frank or SAFE Act, having to incorporate the ARM loan in the transaction. Now, does that mean you shouldn't do it? Well, my answer to that is no, because I think you should process every buyer in that instance. Next, they're getting $21,000 in cash. Now, getting cash isn't a negative because you can provide a receipt and have them sign off on that. We always prefer cashier's checks, and especially as a closing agent, if we're handling the closing on this transaction, we're not going to want to take $21,000 in cash. We're going to want money orders or a cashier's check, obviously. And that's not hard to get that down the road. And so I would give the buyer a receipt for the $21,000. I would see to it that that money goes to the escrow agent, closing the transaction. I would give the buyer a buyer's temporary lease. I would then get my contract signed for my disclosures as soon as possible to ensure they have time to review that. I'd get my buyer processed, and then I'd close it. Too many investors, you know, they have dollar signs in their eyes, and I understand that. I mean, my gosh, we do too occasionally, I know that. But you've got to pull back from the brink every once in a while and consider what you're doing, and are you putting yourself at risk? And there are easy ways to do this, and buyers aren't going to have an objection to signing a short-term lease, signing a contract, getting processed, having a third party hold the money, and close the deal properly. So just slow down a little bit and think about it and do it the right way.
Okay. Here's another question out of Houston. My borrower has an IRS lien. Can I still sell on my house without being affected?
I hear that constantly. The answer is absolutely not a problem. In fact, I don't care if they have an IRS lien or a child support lien or any other kind of lien. It doesn't matter. When you sell a home to somebody, or if you're buying a home and you're using a third-party mortgage company to close it, now from an underwriting perspective, you may want to take that into consideration. But that lien will not affect the transaction. A purchase money mortgage will take priority over any lien position that a buyer might have. So if they have an IRS lien, a judgment lien, a child support lien, whatever it might be, that they may attach to the property if it can do so, but they're going to be secondary to your purchase money mortgage. Now, just a real quick aside, you know, with an IRS lien, the consideration the investor should be thinking about is, what if I have to foreclose on this property at some time in the future?
Right.
And it's not a negative issue, it's just realizing that the foreclosing trustee, the law firm, has to provide at least a 25-day notice to the IRS in advance of foreclosure. And then that will extinguish the IRS lien if it's out there. But the IRS has a 120-day right of redemption, which means if they want to redeem the property, they have to pay the investor 100% of whatever the borrower owed them. And of course, that rarely happens. But it's just something that I think investors need to think about a little bit. I have zero issue in selling a property to somebody that has an IRS lien,
Okay,
so long as they qualify for everything else.
So if they have an IRS lien, it's against them personally, but then when they buy the house, it then attaches to the house?
It does.
And any other lien as well?
It will. Now, with a homestead, as I talk about often, most liens can be removed fairly easily, but an IRS lien is going to attach to a homestead.
Okay. Next question is, what are you trying to do when you're trying to, what are you going to do when you're trying to foreclose and the buyer files bankruptcy?
Well, first off, I like to scream. I get tired of that, and I see it often. And you can't stop
And they
it.
wait till the very last minute.
Yeah. So, one, I think first off, I'm going to direct the investor to our video for our bankruptcy attorney to look at. But just briefly, because I'm not a bankruptcy lawyer, but I've been through this. When a buyer files bankruptcy, they're going to have about a 60-day period before anything really happens out there. There is a possibility that they could pay you some small amount of money in that 60-day period, but normally it takes about 60 days for the creditor's plan to be approved by the trustee. Now, in this period, they have to pay the trustee a fee. Once that 60 days run, they're going to start paying the investor direct their monthly payment again. In addition, any arrears that are out there will be put into a short-term note, usually between 4 to 6 years with some small interest rate, and the borrower has to start making payments on that as well. Now, if they don't do these things, the trustee can either kick them out of bankruptcy, or the investor can file what's called a motion to lift stay, which gives them permission to foreclose. Now, as an investor, one of the important things they should consider is the court is going to send them what is called a proof of claim. They need to fill that out and mail it back to the trustee, because if you're holding a real estate mortgage, you're going to be a secured creditor. Unlike a credit card company, it's going to be unsecured or things of that nature. And we want the court to know who we are, what we're out there, what the terms of our transaction are, so they have that, so they can assure that the borrower is going to wind up paying us after this 60-day time frame runs.
Okay.
Now, unfortunately, Susan, what can happen is they could be dismissed because they don't pay the trustee. You go out, you repost, and they refile again. And oftentimes they'll get the chance to do that. Sometimes you'll see if they're married, one spouse files, they go through the 60 days, maybe it goes out 90 days or more, and they get dismissed for not following the rules. And then what happens is you repost for foreclosure, and then the other spouse files. And that can happen. There are some attorneys out there who do those kind of things just to delay matters further. That's about as far as they're going to go, because at some point the court's going to go, we've had enough.
Right.
And they'll stop them from doing that.
So if one files and that's 60 days, and the other, then you go back, you foreclose, and the other one files, and that's another 60 days, you're talking about 6 months.
Oh, it's going to be more than 60 days. It's going to be 90 to 120 days or 150 days before you can get back to your foreclosure status. And so they can play the game, as we kind of call it, and set up a delay for anywhere from minimum of 90 days up to, probably 8 or 9 months if they want to do it.
And you have to pay that mortgage.
And as the investor, if you have an existing mortgage on the property, you need to maintain it along the way. It's just one of the risks of our transaction out there. So you always want to be thinking about that. No, that's probably the worst thing that can happen. And make certain that you have reserves to cover that.
Yeah. Okay. This is a question that our RMLO gets often. Do I have to charge taxes and insurance to my buyer when my underlying lender is collecting the same?
So I hear that occasionally, and the answer is really simple, because what if the investor has an existing mortgage in which that mortgage company is collecting escrow, taxes, and insurance? Obviously, they have to pay that monthly as part of the mortgage obligation.
Right.
When you sell a property to a buyer, that buyer becomes the owner, and paying taxes becomes their obligation. It's not an option, it's their obligation to pay it. In addition, that borrower needs to provide insurance. If not, we as the investor have to put force-placed insurance on the property, because the existing mortgage company is going to require an insurance policy to be in place, set up properly. Now, what I hear so much when I get those kind of questions out there is that they're trying to keep their buyer into a specific monthly payment. And they'll calculate out a sales price, they'll have an interest rate, and it creates a monthly payment that the buyer can afford. The only problem is they're not thinking about the taxes and the insurance as part of that total payment. And the investor will go, well, I'm collecting over here $2,000 a month in principal and interest, but my payment to my mortgage company is $1,400 a month, which includes taxes and insurance. I'm happy with $600, therefore I'm not going to charge my buyer taxes or insurance. And it simply doesn't work that way. What they need to do is they have to back off of their sales price or the interest rate so that their monthly payment, when you add the actual taxes and insurance to it, will then get them to that monthly payment they're trying to get to. But it needs to be a pass-through scenario where the buyer is paying the investor taxes and insurance, and the investor passes that through to the underlying mortgage company.
Okay. This is another question from our RMLO. Do I really need to process my buyer? She hears this all the time. Why do I have to process my buyer? They may have a hard time paying the extra process fee.
Well, and just like the RMLOs hear this in the marketplace, you know, I hear this constantly when we do seminars. We hear this constantly because it is an added expense. And who should process the buyer? And so, again, you fall back going, what are the compliance issues? So the SAFE Act requires you to process a buyer. We have that 5 property de minimis rule here in Texas. Most states don't have that, by the way. They have, for every transaction, you must incorporate the RMLO into the transaction. So I just diffuse real quick that question and go, process the buyer every time. Now, there are many, many reasons for that. But primarily, I want to ensure, first off, that the borrower has the ability to make the payments. I want to gather information. I like utilizing a third party to do so through a licensed RMLO. When using a licensed RMLO, it helps me comply not just with the SAFE Act and Dodd-Frank, it helps me comply with RESPA. Even in Texas, where you have this 5 property de minimis rule, RESPA, which is the Real Estate Settlement Procedures Act, has a 3 property de minimis rule. So if you do 3 or more, you still must provide them all of these disclosures. So it kind of backs down that requirement to 3 properties. But even so, I like to take the guesswork out of this. I like to incorporate the RMLO into every transaction. And when doing so, what I have found is it normalizes the transaction. In other words, by that I mean if you go to a mortgage company to buy your home, doesn't matter whether it's one of the big banks or some other mortgage company, you are going to go to a loan processor and be processed. And so whenever you can normalize a transaction, you can make it feel the same as if any other, lender is providing money. I think it's just as a positive for the transaction overall.
Okay. Here's a good one, because we have a lot of realtors who bring buyers to us. What do you do when a realtor is involved and they insist on title insurance for their buyer?
So that happens often. And the reason it happens, as you probably well know, is that in most transactions, a seller is providing title insurance for a buyer. And the reason for that is, under RESPA, it is negotiable. It can go either way. But traditionally, at least here in Texas, sellers pay for the title policy. And so most realtors are indoctrinated into that transaction. So I always try to make some simple explanations. First one is when you are handling a transaction with a realtor, the buyer is going through a traditional third-party mortgage company, and the seller is getting 100% of their sales price in cash in some format. Well, with a seller finance transaction, we're not getting 100%. We're getting 5, 10, 20% of the sales price, nothing else. So the way I look at that is since I'm not getting all of my down payment, I'm not going to pay for the buyer's title policy. So that's the first thing I look at. Secondly, I make certain that the agent understands that a title search is always going to be done on the property. Third, I let them know that the original seller of this property had a homestead. I try to explain to them what that means and how liens really can't attach to the homestead, except for a very few here in Texas at least. And that when that original seller bought the home, there is an existing title policy incorporated with the underlying mortgage. So it takes a little bit of proper explanation to the agent to pull them back a little bit, because they're used to just having one in a standard basis. And the agent is trying to protect themselves and understand that. So knowledge is power again in that instance. From there, if a buyer wants title insurance, I am not going to tell them no. That is, if they're willing to pay for it, they can do it. I'm never going to tell a buyer not to do that if that's what they want. I just want them to understand what their needs are, because normally the reason we have title insurance is that if a lender is going to give somebody X amount of dollars to buy a home, they say, I want you to give me a title policy. But in a seller finance transaction, the lender is the seller. The seller, who's now the lender, they don't need a title policy. So therefore, the burden shifts back to the buyer again. Do they really want a homeowner's policy? And what is it you're looking for from the time that the underlying mortgage was issued, along with the title policy, to today? The last thing I just want to bring up is oftentimes when the underlying debt, if there is one, is an FHA, VA, or a home equity loan, title insurance isn't available even if the buyer does want it.
Okay.
So again, it's just having an understanding of what title insurance is, why we need it, who wants it, and then at the end of the day, I let the buyer make that final decision.
Okay, you mentioned title insurance, title policy, and then a homeowner's policy. Are those one and the same or two different things?
No, they're all incorporated the same. No, title insurance can be an owner's title policy, or an OTP as we call it. It can be a mortgagee's title policy, or a lender's title policy as we call it, or an MTP.
So they're all just different names, but it's all the same thing.
Well, there is title insurance, and there can be an owner's policy that's issued to the owner, and there can be a mortgagee's title policy that is issued to the lender.
Okay.
The mortgagee policy says that the lender's policy is going to be in first lien position, or whatever position it is that they're anticipating.
Okay.
And the owner's policy is going to guarantee them they have fee simple title or complete ownership, subject to any mortgage or subordinate mortgage.
Okay. And what is the price range of these policies?
Simple rule of thumb is about 1% of the sales price.
Okay.
It's usually a little bit less than that.
Okay. So if I'm buying a property subject to the debt,
Okay.
should I get title insurance?
Well, it depends. You know, and again, I hear that all the time. You know, first off, I like to teach investors that about 98% of the homes that investors buy or a realtor is selling, it's a homestead. Here in Texas, there's only a few liens that can attach: a purchase money mortgage, a properly executed mechanics lien contract, or some type of a tax lien, IRS or property tax.
Mm-hmm.
Other states may be a little bit different, I understand, but here in Texas, that's what it is. So understanding that, it's going, what can then attach to a homestead under a legal basis, you know, and really, that can be a child support lien, it can be a restitution lien, it can be a judgment lien, but they legally cannot attach to a homestead. Now, we have a lien class that's on our website for the Owner Finance Network that helps to explain those a little bit.
Okay.
But normally, if we know we're buying a homestead, if we know that limited liens can attach by law, if we're not closing through a title company that wants those liens removed for that purpose, then I believe that oftentimes you don't need title insurance, but we always want to check, you know, title through either a title search and name search or through an abstract of title of some format. Now, end of the day, just like with a buyer buying a home, if an investor wants title insurance, I will never dissuade them from getting it.
We get this a lot. The buyer is paid in cash through their employer. So they don't have tax returns. They're paid in cash. So does that work in qualifying them?
Well, if your buyer is Hispanic often, it could be something else. We see a lot of times where they are paid in cash. Sometimes they're in the construction industry or landscaping industry or others. Sometimes their employers pay them in cash, and they don't have tax returns. And of course, the question is, how can we as an investor ensure that our buyer has the ability to afford the home? Okay, and so first off, we have to understand what Dodd-Frank says, which says we must, the buzzwords, and I'll use little quotations here, are consider and verify the financial information provided by the borrower. So I want the borrower to properly fill out a loan application and put everything in there. I want them to realize that this is not going to go out to a third-party bank or to the IRS. It's me. So tell me what it is you really make and what jobs you really do. So that's the first thing. And let me know what that is. Secondly, I'm going to ask them to construct a letter that, again, defines what they do on their job. You know, I work for XYZ, I'm paid in cash, I make X amount of dollars per month. Maybe they have one job or two jobs. Maybe husband and wife have several jobs. I want them to put all that in there in a way so they're telling me what it is they're making. I want them to identify that they understand what the payment amount is and affirm that they have the ability to afford that and make it. And what I'm looking for is for that borrower to give me what it is they're really doing. What are they making? So I can then look at that and make an informed decision.
Okay.
You know, the thing is that, you know, if someone was to create an issue about that, I'm relying upon the information provided to me by the borrower that says and that they can afford the home. And of course, you know, I don't want to have any ridiculous debt-to-income ratios. If it's 70%, I'm not going to qualify them. But if it's 45% debt-to-income ratio or something that's reasonable like that, along with their expenses, and they're telling me what it is they make and they can afford it, then I just want to document my file with as much as I can. Do they have bank accounts? Sometimes they do, sometimes they don't. I don't know. You know, what we do, maybe we can help go through their rental from their where they're leasing previously to help show they can afford at least a certain payment amount as well. But it's all about documenting your file as much as possible to ensure that they can afford the home.
Okay. What do you do if a buyer only has $10,000 to put down, but the down payment is $15,000? Do you just say no? Is there a way around working with them if they don't have enough?
Sure. So the question is a lot of buyers are good buyers who can afford the home, right? And they may have, sometimes they have all the down payment, they don't have the closing costs. Maybe, as you said, that you're asking for a $15,000 down payment. They've only got 10, and of course, they're going to have some closing costs associated with buying a home as well. So we're dealing with maybe not just the $5,000 difference, but maybe $7,000 or $8,000 for everything. And so the first thing I look at is, you know, do they have the ability to make the monthly payment? That's the first thing. Secondly, can I take the $10,000, close the transaction, and can I put the balance of the down payment and closing costs into a second lien? And of course, I'm going to ask the buyer what they can afford. Can they afford an additional monthly payment of $200, $300, $500 a month? Sometimes they can, sometimes they can't. Can they make an extra payment when they get their tax returns back each year? So they get a large chunk of change they can put down. And from there, I'm going to look at the overall picture. You know, how good is the buyer? What was their previous rental amount? What is their debt-to-income ratios? We've got the $10,000. Are they really going to walk away from $10,000? How long do I need to structure my second lien? Are we talking 3 months, 6 months, a year, or 3 to 5 years? So I look at all that together to make that informed decision.
Okay.
But at the end of the day, the decision really rests with the investor on their comfort levels of doing that.
Yeah. Okay, you said 3 to 4 to 5 years. Would you do a second lien that long? Or do you want to get the rest of that money pretty quick? Or is it really your decision?
I want to try and get as much money from the buyer as possible, because that gives them more skin in the game, which means there's less risk of them walking away. So I want to keep that as reasonably short as possible. Now, for instance, if I'm dealing with a smaller home in the $100,000 price range, and I'm talking a $10,000 down payment versus $15,000, I might be okay with that, and going a little bit longer on that. If I have a $300,000 home, though, where the down payment is $30,000 and all I have is $10,000, I may want to consider them under maybe a lease option that fits within the various property codes that are out there, so that they have time to accumulate a little bit more. So it's all going to be a reasonableness factor in how you look at that overall.
Hey guys, if you like this video and want more free information on owner financing, please subscribe to our channel and hit the notification bell to be notified when we post. Don't forget to like this post and ask me any questions on owner financing below. When you're ready to take the next step, head over to the ownerfinancenetwork.com and check out our in-depth course on owner financing.